Good morning. My name is David Berkey. I am a partner at the law firm of Gallet Dreyer Berkey, LLP, and we represent more than 250 cooperative and condominium buildings in New York City. I'm going to speak to you today about insurance, about why cooperatives need insurance, how the provisions of the proprietary lease work concerning insurance, and how you may have the opportunity to review your lease with your lawyer and improve the insurance provisions of your lease. So let's talk a little bit about insurance, why we have it. The proprietary lease has two paragraphs that deal with the obligation to repair the building. There's a paragraph 2 and generally a paragraph 18. 2 has the landlord's obligation to repair, and 18 has the lessee or tenant's obligation to repair. What boards need to do is protect themselves against the cost and expense of repairing their building and portions of the apartments in the building in case there is a fire, a flood, or other catastrophe that's covered by multi-peril insurance. There is another provision in the proprietary lease that deals with damage to the apartment or the building. That is the paragraph, usually it's paragraph 4, that we'll talk about this morning. What that essentially says is if there is such a catastrophe, the board or the cooperative is obligated to repair the building and those portions of the apartment that are not necessarily the specific obligation of the lessor to repair, but instead have been shifted to the lessee by paragraph 18 of the lease. So what kinds of problems can you face? There can be a fire. There can be a flood. The flood can come from an upstairs tenant leaving his tub on, not turning it off. There can be a natural disaster. Hurricane Sandy comes to mind, one of the worst disasters we've had in New York in a long time. Insurance is meant to deal with these issues. So what a board is obliged to do by paragraph 4 is to consult with its insurance broker and obtain that type of multi-peril policy of insurance, which is commonly carried by cooperative corporations in New York City. And that's the language that you'll see in the lease. What I tell boards to do is go generally one step beyond, because a board that isn't careful can obtain a common policy of insurance without reviewing the exclusions in the policy. And if you get to review those exclusions, which could be environmental exclusions, which cover mold issues that you have, or water damage exclusions, which could cover that flood coming from the overflowing tub, you will not have the coverage that you think you should have. So deal with your professional, make sure that you get affirmative insurance, which will eliminate the problems posed by exclusions, and therefore have adequate protection for the building. What else should you be looking at? First of all, most provisions in proprietary leases dealing with damage to the apartment or building do not carry an affirmative obligation on behalf of the lessee to acquire the lessee's own insurance. You should amend your lease if it does not have that paragraph to include one. And the lessee should be required to obtain not only liability insurance in case the lessee causes the flood, but also property damage insurance in case his neighbors cause a flood that damaged the lessee's property, or in case there's a natural disaster that causes damage to the lessee's property as well. In addition, there is a second reason why boards get insurance, and that's to avoid lawsuits. If you have insurance which will cover damage, then you don't have to be litigating the question of who was negligent that caused the damage. If the building's property is damaged, the casualty insurance should cover it. If a lessee's property is damaged, then the lessee's casualty insurance should cover it. There should not be a fight costing thousands and thousands of dollars in attorney's fees to determine who is responsible. So insurance solves that problem if the insurance policy also contains a waiver of subrogation clause. Now, this is a term of art. It means that if the insurance company pays money to the cooperative, the insurance company can stand in the shoes of the cooperative and sue the party whose negligence caused the loss that the insurance company paid for. A waiver of subrogation clause will eliminate such a lawsuit for the protected people who are protected under that waiver clause. So most co-op policies have a waiver of subrogation clause preventing the insurance company from suing its lessees. Why would you want that lawsuit to ever occur? You don't, so you get the waiver clause. And note, if an insurance company sues a lessee because there is no waiver of subrogation clause, the lessee is going to sue the co-op too and say, not my fault, your fault, okay? So you need to avoid the costs of litigation, and the waiver of subrogation clause is important and allows you to do so. One minor point about the language in those clauses that you should be aware of. If the insurance policies have a waiver of subrogation clause, then the lease provisions say the party responsible for the loss is released from any claim or responsibility for that loss. So those two things go hand in hand. The waiver clause and the release go hand in hand. But the release means if you are insured and your insurance company pays you, but you unfortunately had a high deductible and you didn't collect 100 cents on the dollar of your loss because you self-insured for the deductible, the release clause prevents you from suing your lessee to get that deductible amount back. So when you set your deductibles, bear that in mind. So just to recap, the insurance clause is really important because it will help you eliminate the monetary expense of repair that's imposed by paragraph 2. You'll get the money for the repairs from the insurance company. You'll eliminate the need for lawsuits to determine who's responsible and the time, effort, and attorney's fee expense in going after the person who was responsible. If you put in a protective provision requiring your lessees to obtain insurance, then you avoid the lawsuit from the lessee against the co-op claiming you're negligent, or a lawsuit by a lessee against a neighbor claiming the neighbor is negligent. So please pay close attention to the insurance clause, review it with your attorneys, review it with your insurance professionals, and then you'll be well protected. Thank you.